Hi everybody, and welcome back to another episode of Ask My Buddy the Lawyer. My name is Adam, I'm your host, and I'm also a licensed lawyer. Now this week's question is, should I have a written will? The answer is yes. Yes, you should have a written will. Yes, you.
Why?
Now the sad fact is that we're all going to die someday, which means that someday, eventually, you will probably die as well. I know, it's okay. Now you want to have a written will so that you can have some sort of semblance or control over what happens to your estate after you die. So what happens to your stuff after you die if you don't have a will? Well, when someone passes away without a will, that's called being intestate. Now intestate means that the state will decide what happens to your assets after you pass away. Now every state has different intestacy laws. Now you'll want to check with a licensed attorney who is competent to practice what's called probate laws in order to determine what your state's intestacy laws say. Whoa, relax. I said probate, not probation. Probate means establishing a will and an estate in court. The Uniform Probate Code is a good general guideline to most states' intestacy laws. Generally, when someone dies without a will, all of their assets pass on to their surviving spouse. Now, if there's no surviving spouse, then it passes on to their surviving children. If there are no surviving children, then it passes on to their surviving parents. If there are no surviving parents, then it passes along to their surviving brothers and sisters. Seems simple, right? But sometimes it can get kind of complicated. Let me give you for example. Now, if you die and you're survived by a spouse, and you and your spouse have children, but you have children from a previous marriage who aren't
your spouse's children, and your spouse has children from a previous marriage who aren't your children, and your spouse will receive up to $100,000 of your estate with the remaining being divided up by your children, but not by the children of your spouse who are not your children. And you also have to have a name of somebody who's going to be deemed a trustee to make sure that your children's assets are going to be handled properly.
See, it can be very complicated. So it's much easier to have a will written up so you can designate who gets what. Further, when you pass away, someone's going to have to be named a guardian or executor of your estate. Now that person is going to be in charge of divvying up your estate amongst your heirs, either according to the will or according to the state's intestacy laws. If you don't have a will, then the state will pick the guardian and the executor for you. If you do have a will, then you have an opportunity to name that person, so you can make sure that your evil twin brother isn't the one that ends up handling all of your stuff after you pass away. Anyway, that's it for today. I hope you found this video informative. Please keep sending your questions to Ask My Buddy the Lawyer on Facebook, on email, and on Twitter. And don't forget to keep watching our videos, share them with your friends and family, and don't forget to subscribe to our YouTube channel. Thank you very much, and we'll talk soon.